Turn to the fifth case on this morning's docket, case number 116899, State of Kansas v. Maceo Palacio.
Judge, Chief Justice, I would like to ask for 4 minutes rebuttal, please.
If you could start by announcing who you are and who you
Oh,
represent.
yes, I'm glad to. Gerald E. Wells for Mr. Palacio, who's the appellant in this case. This case comes out of
counsel. How many minutes did you ask for?
4, please.
4. That's granted. Thank you.
In summary, this case comes out of a jury verdict in Saline County where Mr. Palacio was found guilty and convicted of first-degree murder and associated felonies. There are 2 issues in this case that are presented to the court today, whether or not the statement and confession of Mr. Palacio should have been suppressed by the court in contradiction to Miranda and the Fifth Amendment. The second issue surrounds the question of whether or not there should have been a change of venue. I would like to focus my attention on the issue of whether or not Mr. Palacio's statement should have been suppressed by the court. And in that regard, there are 2 undisputed evidentiary conclusions. First of all, it was clear from the evidence that Mr. Palacio invoked his right to talk with a lawyer. In fact, he said that very thing. I just want to talk to my lawyer. Subsequent to that, the 2 detectives, veteran detectives as a matter of fact, began to interrogate Mr. Palacio. The general rule in this kind of a...
You characterized it as an interrogation.
I did.
Let's talk about what is an interrogation at that point when there's an invocation of counsel. Here there was an interview that was going along, pretty much a give and take. You say 2 veteran detectives or however you characterize it. One was kind of sitting off to the side, not saying much.
Right.
And at a certain point, he does invoke his right to counsel. I better talk to a lawyer about that. And within a second or 2, okay, let me inform you what you're charged with. Is that interrogation? Let me inform you of what you're charged with.
If you take...
Is that a question that's impermissible?
Well, it may not be isolated, but if you take all of the questions, and there were 4 questions that I think are important to this issue. If you take all of the 4 questions, then the question becomes whether or not those words or actions of those detectives, whether or not those detectives should have known...
Let's take the 4 questions.
Okay.
You're going to be charged with felony murder. Actually, it's not really even a question, it's a statement. That's fine. You're going to be charged with felony murder and shooting in an occupied vehicle. Your girlfriend is being charged with felony obstruction and child endangerment. And then from the other, do you have any felony convictions? I have some pending charges. Drug convictions, yes. Okay, so that's what's happening. And then he says, I want to say something else.
Well, there was some more statements. There was Cox, Detective Cox, when he had a turn at him, said, think about some poor girl's parents.
That was before.
Yes.
That was before.
That was additional.
Wait a minute.
That was an additional statement that was made.
Before the invocation of the right to counsel.
Yes, that's true. So it's our purpose here today to show to the court that there was a systematic series of questions which were clearly designed to elicit an incriminating statement from Mr. Palacio. And the state of the law is that in, I quote, Road versus Ennis case, which is also cited by the state in this case, if it is reasonably likely to elicit an incriminating statement, then those particular actions are unlawful under the Fifth Amendment and Miranda.
And you got a remedy for those. you got a remedy in the suppression of the material that happened between the invocation and the time when he said,
Yes.
"Have a seat, gentlemen. I've got a
Yes.
story for you."
There was a suppression hearing, and that those statements were allowed to come in that he made after those statements were made to the detectives. Now, let me take an example, if I may. He was told, Mr. Palacio was told, that his girlfriend would be charged with serious felony crimes. Now, the point of that is the fact, and the message to Mr. Palacio is, if you confess and cooperate, we will do something to help your girlfriend. I think that's the clear message to Mr. Palacio. And I think that if you take these as a whole, those that were stated after he invoked, then I think there is a very serious question of whether or not they were leading him down the path. And that path was to get him to confess. And I think that if you look at these questions as a whole, I think they were designed, after all, one of their jobs is to get as much information as you can out of a defendant, except in this case, he invoked. So I think if you take that as a whole, I think there is sufficient evidence for this court to find that the court should have suppressed those statements because they made statements and questions to Mr. Palacio, which would elicit a response from him that would have been unlawful.
Counsel.
No, go ahead.
Go ahead.
No, you go ahead.
I'm just going to ask, what's the best case to support your argument that you can provide to us?
Pardon, I didn't hear.
What is the best case that you can provide to us to support your position? You've mentioned Ennis. Is there something that is factually more similar than an Ennis?
I used the Ennis case. There is an additional case which used and cited the Ennis case, and that's State versus Walker, which is found at 276 Kansas 939. And in fact, Justice Looker wrote that opinion. And that follows the precept of and the principle of the Ennis case.
All right. I cut off Justice Rose.
No, I distinguished State v. Garcia, which is also a case that we've had that says that it's not interrogative to ask following invocation, name, physical description, type of car, addresses of relatives, prior arrests, name of parole officers. None of those questions were found to designed to talk about the crime in question. And what's different about that and what happened here?
Well, I think Garcia can be explained away and distinctively in that, remember, one of the questions, in fact, was he was told that his girlfriend was going to be charged with some serious crimes. Now, what does that mean to him? That means that the mother of his child is going to be charged with some very serious felonies. What in the world is the purpose of asking that or stating that? The purpose would be, come off this, your invocation, let's have a statement from you, because they're putting pressure on him through that statement. And it's led, I know it was stated before the invocation, where Cox said, think about the poor girl's parents. I mean, that's all leading up. That's a precept and a prelude to what was stated later. And although they can go into felony convictions, I think that's so. But the two statements that I think are particularly damaging are, and I think you can reasonably take it as a threat. If you tell someone, look, we've got your girlfriend in the next room here, and we're going to charge her with some serious felonies. Well, what is the purpose of making that statement?
That isn't what happened. But let's say we buy your argument, but then he did waive his right to counsel. What happens to that waiver of right to counsel? Should they have just dropped it? What should we do with that?
Well,
He said, I want to talk to you.
I don't think that, there's a case that I quote in the brief wherein it says that you can't do away with, or you can't revocate a prior invocation of counsel, and then they can ask more questions or make more statements, and then that doesn't work anymore. I think that case covers that point. I will say, in addition, the state has raised that this is harmless error, and I think that that can be distinguished as well under State versus Ward, which is quoted by the state. But that particular case says, if there is a question that implicates the Constitution, and it does clearly here, the Fifth Amendment, then this court's got to decide, or a court's got to decide, that there is reasonable doubt that this issue would have no impact on the trial itself. Now, everybody in this room knows that if you are mounting a defense to particularly something this serious, that a confession is your worst case scenario and your nightmare, as a matter of fact, and that's what this is. So I think the harmless error is not a good issue for the state. I think clearly Ward says that if you've got a constitutional issue, then this court or a court has to make the decision as to whether or not that would have no impact on the issue itself. So I would make that point to the court at this point. I'm getting very close to the end of my time. We would ask that this court suppress the statement for the reasons stated in the brief and in this argument, and remand it down for a new trial. That would be our wish. And also, I haven't spoken about the second issue, which is change of venue. I think our briefs go through that issue, and it's very clear as to what the issue is, so I wouldn't add anything to that.
Can you clarify what relief are you asking for us to find presumed prejudice under Skilling and the constitutional standard, or prejudice under the statutory standard?
Statutory. I think that's the case.
Do we have any more questions? Thank you, counsel.
Thank you.
Good morning. Ellen Mitchell, Saline County Attorney, on behalf of the state of Kansas in this case. Two issues. The issue as to change of venue. It's an abuse of discretion standard. The court here made specific findings as to each factor under presumed prejudice and prejudice using the Skilling and the Carr cases. The defendant does not allege that there's insufficient facts to support those findings of the court. What they're asking you to do is to reassign the weight that the trial court gave, and it's the state's position that that is not the appellate court's job to reassign the weight that the court attributed to each of those factors.
Well, actually, the court went through both analyses.
It did.
And went through every factor, the Skilling factor, and then the statutory factor for actual prejudice.
That's correct.
How would you distinguish the cases in which we have reversed the district court for denying a change of venue?
I don't think that's ever happened.
Correct.
I was worried there, but I don't believe that has happened.
You've noticed I had my tongue in my cheek.
I saw it from over here.
The second issue before the court is the motion to suppress issue. Clearly, the defendant clearly and unequivocally asked for counsel, and the state can't argue to the contrary. The trial court suppressed the evidence or the statement from that point on until the defendant, in the question for the court then is whether the defendant, Mr. Palacio, reinitiated the conversation, and the state has to show that the defendant knowingly and intelligently, voluntarily waived his previously asserted right to an attorney. In this case, I believe it's on video. There were multiple defendants arrested that night, 5, I believe. 5 at some point were charged. And so everyone was called in, and so you actually had 2 supervisors conducting the interview in this case. When Mr. Palacio said, honestly, I just want to talk to my attorney, that's it, and that's when the court began to suppress. However, if you watch the video, the officers are actually getting up and leaving the room when Mr. Palacio, and I believe Lieutenant Cox had said, have a seat out here, we're going to give you a seat out here, we're going to get you paperwork and take you next door. The jail is adjacent to the police department. And so that's when Maceo Palacio said, hey, I'd like to say something else. And Feldman said, what's that? And he told them to take a seat. The defendant told the officers to take a seat. And they said, well, do you want to continue talking? And he said, yes. And they asked, without an attorney? Yeah, I'll do that. And they said, okay. And then he says, honestly, I was there. And then he proceeds to tell them a story. And then eventually he gets to his final story that he was there. And
In between
Pull
the
the
invocation
trigger.
and the reinitiation, what was the purpose of informing him of his girlfriend's charges?
in this case, at the time of his arrest, this happened almost immediately. They had enough information. They went to Maceo Palacio's residence. It was a trailer home that he shared with his girlfriend, Azucena Garcia, and her parents and a child. And they go in and to the home, and they take him and they place him under arrest. They want to secure the home for a search warrant to search for the weapon or any other evidence that there might be. And Miss Garcia and the child have been removed. There was a terrible weather problem that evening, and her parents had left to take shelter because of the potential for a tornado. So she's standing out there with the child, and she asks and is permitted to go in and out to secure things that the child might need, some medication, clothing, that kind of thing. And what she's actually doing when she goes in is she goes in and takes the gun and that was used in this crime and puts it in her pants. And
Why is it necessary to inform Mr. Palacio
Because-
of that?
because what they're telling him in the state's opinion is, we've got the gun. We got the gun. We have your girlfriend. She was arrested for obstruction, I believe, and endangered.
What's the purpose of informing him of the charges against his girlfriend after he's invoked his right to counsel?
Right. Just to
Well,
tell
why?
him, we have where your wife or your girlfriend, whatever she was, and your child. I just think it was a courtesy to him. I don't think there was any other ulterior motive. I know the defense speculates that was an invitation to Mr. Palacio to cooperate to get your girlfriend off or something, but I don't. I believe they were just saying, we've arrested your girlfriend, we're arresting you for these charges, we've arrested her for those. I don't believe that there was any ulterior motive.
And to follow that up then with the question, do you have any felony convictions? What's the purpose of that? Right after Sergeant Feldman says your girlfriend's being charged with felony obstruction and child endangerment.
The officer's testimony and the prosecutor that handled the case argument was that was to determine whether or not there should be a charge of felon in possession of a firearm.
That would
And-
be, in other words, asking if he fit within one of the elements of another crime.
Correct.
And his
After
answer to that
he's-
got suppressed.
That's correct. And we are not arguing otherwise. I'm not arguing otherwise.
Well, I guess I'll speak for myself, but it sounds like some of the questions from the court have indicated perhaps a concern that this discussion is being treated like a centrifuge, and you can spin this around until you find out where they crossed the line and where they didn't. And this really is not a valid analogy because you cannot separate those two. Do you have a position on that?
separate the two, the gun charge and the homicide.
Yes, whatever they said, unless you say he just decided completely on his own, I'd like to say something else now.
Oh.
That's what I'm getting at. Is there any impact of what the first conversation had on the later?
The state doesn't believe so.
And I'm asking
They
you
were
to tell
getting
me
up.
why not.
They're getting up and leaving. In the video. I think they stood up and they tell him, "We're going to have you take a seat out here, and we're going to get the paperwork and get you next door, the jail." And he's the one that stopped them. If he would have remained silent, they would have placed him in the holding cell, the locked holding cell, got his paperwork, and walked him on over to the jail.
So their purposes in asking these questions, number one, a courtesy to him about his girlfriend and the charges that she was being charged with,
Right.
and then pursuing the inquiry to see if there was another crime he could be charged with because he might be a felon in possession.
Correct. And that's what they testified to, and that's what was argued, although that's, I probably would have argued that was an inappropriate question because it is part of the homicide. It occurred with a gun. They know they've got the gun because Azucena Garcia, his girlfriend, stuck it down her yoga pants, and they could see it. And then, so the felon in possession would have been related to the homicide.
All right, thank you.
I don't really have any other argument. I would ask the court to affirm the trial court, both the decision to not change venue, noting also that we really had very little. I did help with the trial in this, and there was very few problems selecting a jury. We were able to impanel a jury. That, of course, when the trial court made its determination, we didn't have the benefit of that, but the trial court did take some extra steps. We sent out questionnaires, agreed to interview in smaller panels, and we went into the judges' chambers. You can't deny that there were some people that said, that they'd heard about it. It was very heartbreaking. But when you brought people in and actually questioned them, when they said no one was saying kill the defendant or hang the defendant or whatever. Most people were saying my heart goes out to Ali Sam's family because at least in the crimes that we have, generally they're associated with a drug problem or a drug fight or something, or a bar fight, that kind of thing. And this was a totally innocent young couple driving down the street, a case of mistaken identity. But everybody agreed to follow the law, and there really wasn't any proof or evidence that anybody was, the jury wanted to convict anyone other than the person who committed the offense. And I'd also ask that you affirm the trial court's suppression determination, suppressing only that portion that occurred between the time he invoked and the time that he asked the administrators from the police department to sit down, come back in. He had something to say, and to sit down and began his story.
Counsel, assume, just for argument's sake, that we would disagree with you, and we would say that that is error.
Correct.
Can you take us to the harmlessness, reversibility issue?
The evidence was pretty overwhelming. Otherwise, in the case, there was a co-defendant that testified. The evidence, the gun was found at his home. The gun that was found at his home matched the ballistics. We hired a firearm examiner from, I believe, the Sedgwick County office. We weren't able to use anyone from the KBI. They didn't have anyone available, and we hired somebody, and they were able to match the bullet and I believe a couple of the shells. The testimony of the co-defendant primarily in this
Weren't
case.
there more than one person that testified that Mr. Palacio was the shooter? Or was it just the one co-defendant?
I think just the one co-defendant. I'm having difficulty because a couple of these went to trial and they
They've got
were,
pled, you're right.
and they were tried differently because not all the witnesses showed up for each case, but I believe it was just Daniel Sims that testified.
Any more questions? Any further presentation?
Thank you.
Thank you, counsel.
Judge, the state has brought out the point I was going to make on rebuttal.
If you could stand at the lectern so people watching live streaming can see you.
Judge, I think the state brought out the point I was going to make on rebuttal, plus I think the harmless error issue we've addressed, and so I don't have anything further on rebuttal. Thank you.
Any more questions? All right, thank you, counsel.
Thank you.
Thank you both for your arguments this morning and this afternoon. Court will take this matter under advisement.